just going to continue where we left off at. Right over here. The law app. Let's click on this. And it's let her teach.
Application. Section 501B2, 50 U.S.C. 1861B2 is amended. In subparagraph A, in the matter preceding clause I, by striking a statement and inserting, in the case of an application other than an application described in subparagraph C, including an application for the production of call detail records other than in the manner described in subparagraph C, a statement, and in clause E, by striking and inserting a semicolon. By redesignating subparagraphs A and B as subparagraphs B and D respectively, and by inserting after subparagraph B as so redesignated the following new subparagraph. C. In the case of an application for the production on a daily basis of call detail records created before, on, or after the date of the application relating to an authorized investigation other than a threat assessment conducted in accordance with subsection A2 to protect against international terrorism, a statement of facts showing that there are reasonable grounds to believe that the call detail records sought to be produced based on the specific selection term required under subparagraph A are relevant to such investigation, and there are facts giving rise to a reasonable, articulable suspicion that such specific selection term is associated with a foreign power or an agent of a foreign power, and order. Section 501(c)(2), 50 U.S.C. 1861 (c)(2) is amended. In subparagraph D, by striking and inserting a semicolon. In subparagraph E, by striking the period and inserting and by adding at the end the following new subparagraph. F. In the case of an application described in subsection B2, C, shall authorize the production on a daily basis of call detail records for a period not to exceed 180 days. Provide that an order for such production may be extended upon application under subsection B and the judicial finding under paragraph 1. Provide that the government may require the prompt production of call detail records using the specific selection term that satisfies the standard required under subsection B2, CE as the basis for production, and using call detail records with a direct connection to such specific selection term as the basis for production of a second set of call detail records. Provide that, when produced, such records be in a form that will be useful to the government. Direct each person the government directs to produce call detail records under the order to furnish the government forthwith all information, facilities, or technical assistance necessary to accomplish the production in such a manner as will protect the secrecy of the production and produce a minimum of interference with the services that such person is providing to each subject of the production, and direct the government to adopt minimization procedures that require the prompt destruction of all call detail records produced under the order that the government determines are not foreign intelligence information, and destroy all call detail records produced under the order as prescribed by such procedures.
Alright, that's that one.
Here's how we're gonna stop making excuses and learn those languages next year. You throw on a little Pimsler and you do the chores you had to do anyways.
Now say,
As soon as I get out the money, I'm going to go ahead and buy this so that we ain't got to do with the ads.
Emergency Authority for Production of Tangible Things. Emergency Authority for Production of Tangible Things. Notwithstanding any other provision of this section, the Attorney General may require the emergency production of tangible things if the Attorney General reasonably determines that an emergency situation requires the production of tangible things before an order authorizing such production can with due diligence be obtained. Reasonably determines that the factual basis for the issuance of an order under this section to approve such production of tangible things exists. Informs, either personally or through a designee, a judge having jurisdiction under this section at the time the Attorney General requires the emergency production of tangible things that the decision has been made to employ the authority under this subsection, and makes an application in accordance with this section to a judge having jurisdiction under this section as soon as practicable, but not later than 7 days after the Attorney General requires the emergency production of tangible things under this subsection. If the Attorney General authorizes the emergency production of tangible things under paragraph 1, the Attorney General shall require that the minimization procedures required by this section for the issuance of a judicial order be followed. In the absence of a judicial order approving the production of tangible things under this subsection, the production shall terminate when the information sought is obtained, when the application for the order is denied, or after the expiration of 7 days from the time the Attorney General begins requiring the emergency production of such tangible things, whichever is earliest. A denial of the application made under this subsection may be reviewed as provided in Section 103. If such application for approval is denied, or in any other case where the production of tangible things is terminated and no order is issued approving the production, no information obtained or evidence derived from such production shall be received in evidence or otherwise disclosed in any trial, hearing, or other proceeding in or before any court, grand jury, department, office, agency, regulatory body, legislative committee, or other authority of the United States, a state, or political subdivision thereof, and no information concerning any United States person acquired from such production shall subsequently be used or disclosed in any other manner by federal officers or employees without the consent of such person, except with the approval of the Attorney General if the information indicates a threat of death or serious bodily harm to any person. The Attorney General shall assess compliance with the requirements of paragraph 5. Conforming amendment. Section 501D, 50 U.S.C. 1861D, is amended. In paragraph 1, in the matter preceding subparagraph A, by striking, pursuant to an order, and inserting, pursuant to an order issued or an emergency production required. In subparagraph A, by striking, such order, and inserting, such order or such emergency production, and in subparagraph B, by striking, the order, and inserting, the order or the emergency production, and in paragraph 2, in subparagraph A, by striking, an order, and inserting, an order or emergency production, and in subparagraph B, by striking, an order, and inserting, an order or emergency production.
Alright, there's that one.
Hot take for all my bed-rotting girlies. If you're depressed and your house is always a mess, the support you need should be free. If you're procrastinating, depressed, stuck in bed and not texting people back, someone created an app to support you. And you can use it without paying anything.
Application. Section 501B2, 50 U.S.C. 1861B2, as amended by Section 101A of this Act, is further amended by inserting before subparagraph B, as redesignated by such Section 101A of this Act, the following new subparagraph. A specific selection term to be used as the basis for the production of the tangible things sought. Order. Section 501C, 50 U.S.C. 1861C, is amended. In paragraph 2A, by striking the semicolon and inserting, including each specific selection term to be used as the basis for the production, and by adding at the end the following new paragraph. No order issued under this subsection may authorize the collection of tangible things without the use of a specific selection term that meets the requirements of subsection B2.
There's that one. Double check our progress. We got a lot more to go. Alright, this is where we leave off for now. See y'all guys in the next episode.